clauses 16 to 19. The question is that Part 2 stand part. The Honourable David Parker.
Mr Chairman, this Part 2 amendments to the Crimes Act, Part 2 covers amendments to the 1961 Crimes Act that are made by this New Zealand Security Intelligence Service Amendment Bill. The difficulty that we have in this House at this part of the debate is that the commentary on the bill says nothing about Part 2, and therefore when trying to interpret Part 2 we're left to our own devices. Now it seems to me from the changes to or brought about by this part that we are amending provisions in the Crimes Act, and we are amending it by omitting a phrase, sections 249 and 250, and substituting in its place the phrase sections 249 to 252. In other words, by this amendment we are omitting an additional two clauses from the Crimes Act. Now, so my first question for the Minister is, are we repealing those sections, or are we just saying that those sections don't apply to actions by the Security and Intelligence Service? And if so, what is it that we are in practice changing? It appears that at least part of this relates to accessing computer systems without an authorisation, and in that regard it looks like we are repealing section 252 subsection 3, and I presume that we're repealing that for all purposes, not just for the purposes of the Security Intelligence Service, and hence I'm a little surprised in that I can't just off the quick reading or the initial reading of this part of the bill see why we would, in the Security Intelligence Service Amendment Bill, be repealing provisions relating to the Crimes Act. Now, it is possible, I suppose, that there were provisions relating to, in section 252 subsection 3 of the Crimes Act might have had a specific provision exempting the Security Intelligence Service from that particular provision of the Crimes Act, and if we have extended the number of sections that are omitted to include 252, then that omission of those sections might mean that there is no need now to have the special provisions in 2523, which are accordingly repealed. The Minister, I see, has the statute in front of him and might be able to inform. He may already know. The Attorney is very learned in matters of law, and it may well be that he already knows off by heart the provisions of sections 249 to 252, 249 to 252 of the Crimes Act, and whether those sections are of particular application only to the Security Intelligence Service or whether they have wider application. So I look forward to the Minister clarifying that question.
The Honourable Christopher Van Linson.
Chairman, those clauses 248 through to sections 248 to 254 of the Crimes Act were inserted by the Crimes Amendment Act of 2003, and they deal with crimes involving computers. And so the purpose of Part 2 of this bill is to give effect to certain amendments to the Crimes Act. Clause 17 amends section 248 of the Crimes Act, and it inserts a definition of authorisation, which is currently not there. And that's defined as including an authorisation conferred on a person by or under an enactment or by a rule of law or order of the court or judicial process. So that's what happens there. That definition of authorisation is inserted. Clause 18 repeals section 252(3) of the Crimes Act, and that is rendered superfluous because of the definition of authorisation included in clause 17 of the bill. Sections 253 and 254 of the Crimes Act are repealed. Those sections currently give, in the case of section 253, the New Zealand Security Intelligence Service, and in the case of section 254, the Government Communications Security Bureau, gives them a qualified exemption from the offence of accessing computer systems without authorisation, and those sections have become unnecessary in view of the definition of authorisation, which is going to be inserted by clause 17.
Keith Locke.
Thank you, Mr. Chair.